We will hear argument this morning in Case 25A312, Trump versus Cook. General Sauer.
Mr. Chief Justice, and may it please the Court. Deceit or gross negligence by a financial regulator in financial transactions is cause for removal. In a 2-week period in 2021, Lisa Cook submitted mortgage applications for 2 properties in Michigan and Georgia. In both, she told the lender that within 60 days, she would occupy that property for 1 year as her principal residence. As President Trump stated in removing her, it is inconceivable that she was unaware of the first commitment when making the second, and it is impossible that she intended to honor both. Such behavior impugns Cook's conduct, fitness, ability, or competence to serve as a governor of the Federal Reserve. The American people should not have their interest rates determined by someone who was, at best, grossly negligent in obtaining favorable interest rates for herself. Cook's conception of cause contradicts the term's longstanding meaning and overrides Congress's deliberate decision not to impose the inefficiency, neglect, or malfeasance standard here. Her claim that she has a property interest in her public office was roundly rejected by the founding generation as pernicious in a Republican system of government. Her claim that the statute grants her notice in a hearing contradicts this court's cases requiring very clear and explicit language to restrict the president's removal power. And any such process would be futile because for months, she has never personally disputed the substantial truth of the material in question. Finally, the remedy she obtained, a preliminary injunction countermanding the president's decision and reinstating her to office, violates longstanding principles of equity and was conspicuously non-existent in our nation's history from 1789 until 2025. I welcome the court's questions.
General Sauer, this isn't central to the case, but it is an antecedent point. On what basis are we to conclude that the Federal Reserve is an executive branch agency and hence that the president does have a removal authority?
Justice Thomas, an excellent question. I would say 2 things about that. The first one is, of course, that the Federal Reserve, there's an academic dispute about whether or not the Federal Reserve's open market operations constitute executive power or something else, essentially private conduct. However, Congress has, over the years, kind of packed on traditional executive powers on the Federal Reserve. So the Federal Reserve can issue regulations about reserve requirements in banks and even credit card fees and so forth. So even if the court were to think that some of what the Federal Reserve does isn't executive at all, certainly there are traditional executive powers at issue here, and therefore we contend that this, even though we haven't disputed the validity of the Article 2 removal restriction here, this case is not transparent to Article 2. And certainly there's a statutory authority that's very plain here because it says removable for cause by the president. So the statute is unambiguous, giving the president removal power, and we contend that at least there's what's kind of been packed onto the Federal Reserve over the years by Congress is clearly quintessential executive power. Now, we acknowledge what the court said in Wilcox, which is that it's a quasi-private, uniquely structured entity that stands in the distinct historical tradition of the first and second banks of the United States, and therefore we have not challenged the removal restriction in this case.